Hey, ladies and gentlemen and ladies and gents, just completed a motion for someone, something that I had already committed to. See, I said I'm not working on anybody else's stuff, but this one I was already working on. And so just needed a quick response because the notice of appeal needed to be done. So what I'm going to do is I'm going to let you listen to the notice of appeal. Now, I want you to listen to the argument, not so much as what the appeal is about or anything like that. Basically, the court has been blocking this individual. They foreclosed on his home, but in the state where he lived, Colorado, they allow the individual to file. Pay attention, people. They allow the individual in Colorado, anyone in Colorado gets to file a counterclaim. Well, we decided to file a counterclaim and purposely filed it in excess of the court's jurisdiction because we wanted to take it out of that little small claims, little unlawful detainer type court and put it into another court where we could raise our issues. And then we decided in our counterclaim to claim adverse possession because he had been in the house for more than 14 years. Ladies and gentlemen, the court ignored everything. Literally treated him, 70-year-old man, like he was a stepchild. Well, 69. Okay? But they treated him like he was a stepchild and kicked it out of the court. So we appealed it. Well, the first thing we did when the judge made the decision, we decided to ask for reconsideration. The judge ignored the reconsideration, so we decided to ask for a vacating of judgment. The judge ignored that, so we appealed the vacating of judgment and the reconsideration issue. We weren't appealing no stupid final decision. We were appealing the fact the court didn't have jurisdiction in the first place as we took it out of the court's jurisdiction. The moment we asked for, pay attention, a counterclaim, and the moment our counterclaim was in excess of the court's jurisdiction, the court could not determine whether or not it was in their jurisdiction or not because we took it out of their jurisdiction by bringing in that claim. The court could not make a determination on a claim for which it had no jurisdiction to make a determination because, say it again, it didn't have the jurisdiction. You feel me? So that's what we're doing. Now, give me a second because I'm about to get this party started. But what I have to do, because in the midst of getting the party started, I was cooking. That's right, that's Apache here on the stove. I was cooking. So while I was cooking, that's what I'm going to do. I'm going to let y'all hear what I had to say to the court. And I got to add the thing at the end of the video. When I finish with all this, I got to add the part about the so-called, the reason why we brought the appeal in the first place. We were appealing the decision on the reconsideration and the vacating of the judgment. We didn't care about the final judgment because the final judgment had nothing to do with anything. The court didn't have the jurisdiction to make a final judgment. That's what we're appealing. Okay? And this is a procedural thing, but they want to play games. So I want you to listen to how, and I can't make the screen any bigger. I could have taken my screen recorder and focused it right on the screen, but then you'd just be looking at a bunch of words. So I figured we'll let some pictures be in the background, okay? So Dave is going to talk to y'all for a minute. Y'all just sit back and listen.
I no need to educate the court. 1. The court's rambling dissertation is rather disconcerting. The court seems to imply that it is incumbent upon the pro se litigant or any other litigator to explain its actions, and or to explain the rules, policies, and procedures to the court, and we object to any such inference on the part of the court. 2. The court is supposed to be arranged and composed of learned individuals, and yet the court is suggesting that I need to explain to it what the law says, what equity is, and how it must grant and present and provide affirmative relief in equity, and I object. 3. The court is not set up to determine whether or not a person has raised this or that issue. The court is supposed to be set up to redress grievable issues. Every state constitution must recognize the right of the people to petition for redress, i.e. to correct the wrong, implying an expectation that the government would correct what's wrong, that is grievances. So no, we don't have to tell the court how to do its job, we just have to highlight to the court what rights were violated and where the opposing party failed to recognize our constitutional rights. 4. During this long and audacious history of technicalities administratively that there have been problems, and this has been as a result of the so-called continuing declared serious national emergency, and I must object and challenge any statute associated with that so-called declaration of serious national emergency as being unconstitutional and void of enactment. 5. As mentioned to the court, we are in the midst of a current national serious emergency, as has been declared by Congress and United States President, see the March 9, 1933 Emergency Banking Relief Act, and the Act of May 12, 1933, the Federal Emergency Relief Act, and Proclamations 2038 through 2040, and the court must acknowledge and recognize these precedents in law. 2. No statute of limitations in cases of fraud. 6. We have accused the judicial officer of denying an individual due process, which is a cognizable crime under colorable law. 7. We accuse the judicial officer of acting without authority, without jurisdiction, as we had the matter removed from her jurisdiction to federal district court. It matters not what the federal district court decided. What matters is that the matter stating the court matter until there was a decision from the federal district court. This court's opinion, irrespective of the actual facts and conclusions of law, specifically stating that the state court lacks jurisdiction to move one step further because it is in want of jurisdiction once it has received a notice of removal to federal court. 8. The staying of a state proceeding has nothing to do with the decision of the federal court, because that is the federal court's jurisdiction and has no discretion within the state court, even within this the district court. That the court would even bring up with the district court did or did not say when that is not a matter before the court is offensive. 9. The very fact that we were appealing the court's refusal to reconsider its error, documents that regarding the appeal of that decision, whether it be final or not, is our right, and the court doesn't get to deny this right because of some decision it made in the previous case. The court cannot convert a right to a privilege. 3. Suggestion regarding what should have been said and what should have not been said. 10. This court suggested we should explain the rules to the court, that somehow we should have told the court that because we are appealing the failure to hear the matter in the proper venue, and not the so-called final decision, the statute of limitation did not commence to run until the last overt act had been committed and or the court had returned an answer to the reconsideration motion. 11. Or the fact that we are in a current banking holiday, national emergency, state of emergency, their goal a continuing statute of limitation. 12. If the court, whether it be lower court or superior court or supreme court or appeals court, operates without jurisdiction, that operation and more discretion is avoidable. Discretion or operation error, goal conveying no statute of limitations. Jurisdiction may be challenged at any time, even on appeal, and if this body would pay attention to our appeal, we were challenging the court jurisdiction to act in the first instance, which gives us the right to bring forth the appeal and the manner in which we did. 4. Timely notification. 13. This body has somehow assumed and or presumed that it has the authority to deny a right. There is no constitutional amendment and or delegation of authority which gives the court or any other body the right to deny a person a secured right, and we hereby object. 14. Since March 3, 1933, when Franklin Delano Roosevelt announced in his Presidential Proclamation 2038 the need for a special session of Congress, and Presidential Proclamation 2039 that there was a serious national emergency and declared a national banking holiday as a result of Presidential Proclamation 2040, and Congress and their National Emergency Act of 1976 making it a matter of public policy that the national emergency is still ongoing, this body cannot ignore my rights and or my challenge to that statute or that national emergency throughout these proceedings. 15. The declaration by the President in his capacity as President declaring a national emergency was completely within his right. However, the enactment of the March 9, 1933 Act, which conferred congressional authority on the President of the United States in his capacity as President and the capacity as Commander-in-Chief, was wholly illegal, unconstitutional, and a breach of public trust on the part of Congress and the President of the United States. 16. I have, and had a right to challenge the statute during these proceedings, and because of the value associated with these proceedings it was outside the scope and jurisdiction of the Littleton Limited Jurisdiction Court. 17. This matter has been about jurisdiction, and I challenge the jurisdiction of the Superior Court in that court and on appeal, and I did so during the proceedings, and the issue as to jurisdiction has never been addressed. 18. I have maintained, supported by the actual facts and conclusions of law what respects to the federal and state national emergency declarations, that the courts is not of the judicial branch, that somehow the state and federal government has blocked access of the people, of which I am a member of the American people, to their access to the judicial branch. They have created a conspiratorial act of gatekeeping, and I challenge the statute. I challenge the administrative operation of the courts and their non-judicial nature as a matter of course and as a matter of right. 19. I put before this body that according to the United States government, it being their official standing, that the United States government is the owner of all property in the United States, including the property of all of the people of the nation, and that being a matter of fact as enacted by Congress in their General Assembly, and as part of their declaration of a serious national emergency, this court lacked jurisdiction to decide over federal government property ownership rights. 20. I also brought to the attention of the court my right to petition for adverse possession. The right to adverse possession is a state right, of course, both statutorily cognizable as well as common law, predicated on foundational principles of property ownership rights. I had every right to bring forth these arguments, and the value of my claim and the subject matter of these claims deprived the lower limited jurisdiction court of juris. This was what I was appealing, not some final decision of the court. 21. I gave the lower court every opportunity to do the right thing, and it continued to violate my rights, so I brought forth my complaint against that body in the form of an appeal, and this body wants to say that it had the jurisdiction to ignore me, when I have the absolute right to petition for redress of grievance. 22. This body's decision was prejudicial, it was racially motivated, and it was based on segregationist principles, and I object. The courts are supposed to be open to everyone, but because of my color of skin, because of my being pro-SE, this court has decided to ignore what it knows are my rights, and I object. 23. So I do hereby present this my notice of appeal before this body, and to have it acknowledge and recognize my right to present for payment of all fees concerning this instant matter the Social Security Administration Fee Authorization Approval Form 445 for accessing and obtaining the associated fees that are in excess of the fees already assigned by the taxes collected by the state agencies. 24. The court's request for extra fees for services already calculated and assigned through the tax and revenue process amounts to double jeopardy, and I bring forth my claim of double jeopardy in both the state venue and this venue as being unconstitutional, and as being unlawful as a result of the doctrine of double jeopardy. I do hereby present this my notice of appeal along with my fee authorization approval form before this body on this March 3, 2018, and attest that the aforementioned information is based on first-hand personal knowledge and that the aforementioned information is accurate, so help me God.
So, ladies and gentlemen and ladies, it took 11 minutes for this notice of appeal, which goes into detail. It's just not no basic regular notice of appeal. This is a detailed notice of appeal highlighting all the points, because guess what? The person putting it in, let's say something was to happen to dear old moi, and I wasn't able to finish it out for him. He has every issue he needs to raise on appeal. And what he's going to be doing next is he's going to be doing an administrative, pay attention, administrative writ of mandamus, bringing up the exact same points regarding that administrative agency as a result, because remember, they're an administrative agency as a result of the Administrative Act of Congress. Remember, the Act of Congress, the March 9, 1933 Act, was a military act authorizing military authority. The military is an administrative agency of the U.S. government. It's not part of the U.S., but it is an agency, not because it's a corporation, but because it's done under the government's capacity through the president as commander-in-chief. It is an administrative capacity, people. It's not a public capacity, it's an administrative capacity. That's why he cannot act as commander-in-chief and president at the same time. He cannot wear the hats at the same time. So because the Congress gave an administrative law, that law does not apply. They didn't have the authority to give congressional authority to anything or anyone administratively, because Congress cannot be administrative. You guys understand that, right? Congress can only be legislative. It could never be administrative. Administrative can only be the president's office. Separation of powers clause prevents the courts from being administrative. So the courts are under the administrative branch because the executive has the right to set up law officers, administrative judges, administrative law. That's what they've done. That's the Administrative Procedures Act. So you have the right to file an administrative writ of mandamus. Mandamus! Okay? All right, ladies and gentlemen, have a good day. Have a good night. Just wanted to share this with you. And go back and listen to the arguments, because that's your argument if you choose to use it. Goodbye. This message will self-destruct in 5, 4, 3, 2.